Pooh Shiesty's lawyer says he's opening his statement with this.
The worst way to begin an opening statement is, ladies and gentlemen of the jury, as you heard in jury selection, my name is Dan Cogdell. It is my honor and my good fortune to represent Joe Smith. You're going to learn through the course of the evidence that Joe Smith really believed that he had to use deadly force. You're going to hear from juries that he was in fear for that. If you don't ever start with, may it please the court, ladies and gentlemen of the jury, eliminate all the throat clearing. Get right to at 3:50 that afternoon, when he looked down the barrel of that gun that was pointed right between his eyes, he realized he had no choice. If he didn't use deadly force, he'd be attending his own funeral in about 3 days. There was no ifs, ands, or buts about it. Don't start off with this, hi, ma'am, how's it going today? How's your world? That. Start off with a punch right between the eyes, because guess what? The prosecution has already punched them, and if you don't punch back, your client's going to spend a lot of money on commissary.
And today, we got a little bombshell real quick because we go into 2027. Roll it. So you already know who this is, United States versus everybody. You know what I mean? Protective order governing discovery materials. Dun, dun, dun. Before the court is the government's motion for protective order governing disclosure of discovery materials. The motion, in accordance with its findings set forth below, is granted. Whereas the government will provide materials to the defendant in the course of the discovery process. In this case, hereinafter, the discovery materials that may contain personally identifiable information, financial amount, numbers, and other protected information. Right. Got that. And whereas the parties agree that the government has a compelling interest in preventing the discovery materials from being disclosed to anyone not a party to the court proceedings in this matter, meaning we ain't going to see a bunch of names pop up on a lot of shit. So it is what it is on that one. Such material may include information relevant to ongoing investigations, meaning this shit is still going on. So more people may be arrested, and prosecutors in such materials may implicate the privacy interests of victims and of third parties. And whereas the government has shown good cause to restrict discovery in this case, the parties agree that the court has the power under Fedar Crem P 16D1 and 49.1E to grant appropriate relief to the parties where required in the interest of justice. It's ordered. So we get on to the good stuff right here. Amended pretrial order. Before the court is defending Latrell Williams Jr. unopposed motion, meaning everybody agreed. Whenever it's unopposed, I mean, both sides just going to say, go ahead, it's up to the judge at this point. Motion to certify case as complex and motion to enter new scheduling order filed May 27, 2026. The court finds that the ends of justice served by continuance outweigh the best interest of the public and the defendant in a speedy trial for the reasons stated in the motion, and therefore grants the request for continuance as requested and declares this case complex pursuant to 18 U.S.C. 3161 H7B2. The failure to grant the continuance in this case would deny defendant's counsel the reasonable time necessary for effective preparation, taking into account the exercise of due diligence. By taking into account the exercise of due diligence by defense counsel, a continuance of the duration granted by this order is necessary for effective preparation by defense counsel. It's Monday. It's free cash. It's SETI Nash. Y'all know it ain't the 5. It's the 10 to win day. So y'all know what to do. Hit that QR code or tap that link in the description and literally start making your run to the FUNDS. Yeah, that's how you spell that. Free cash, SETI Nash. Hit that QR code or tap that link in the description. Find out how you gonna win today. Y'all can get it in your account. Y'all can get it PayPal. Y'all can get it Venmo. Y'all can even get it through gift cards. Be like, here's Father's Day. Got y'all. Free cash, SETI Nash. QR code or tap that link in the description. Let's get on with the case. This case is set for trial. This court's 1 week docket beginning February 22nd, 2027. Any potential conflicts must be called to the attention of the court in writing, wherein 10 days from the date of this order, the party shall comply with the federal rules of criminal procedure and the local criminal rules of this court, except as expressly modified in this order. The government shall provide full discovery to each defendant in accordance with Rule Sorry, the screen is messed up right here. There you go. 16A, Federal Crime P, 35 days before trial. It needs to finish up, provide full discovery to the government 28 days before trial in accordance with Rule 16B. The government shall, in accordance with Brady versus Maryland, they talk about Brady material, got to be given 35 days before trial, which that's pretty good. We get it about a month and a couple of days before. I actually function with that. The government's pretrial material shall be filed 10 days before trial. The defendant's pretrial material shall be filed 7 days before trial. Specifically, pretrial material shall include a list of witnesses to be filed by each party, which divides the persons listed in the groups of probable witnesses, possible witnesses, experts, and record custodians, which states name, address of each witness, and which contains a brief narrative summary of the testimony to be covered by each witness. A list of exhibits and designations of portions of depositions, all documentary exhibits offered by the government shall be submitted on CD at the conclusion of the trial. They're not doing USBs, man. I mean, God dang. The final pretrial conference in this case is set for February 17, 2027 at 10 a.m. Lead counsel must attend the pretrial conference. All pretrial motions will be heard and resolved at that time, and procedures for trial will be discussed. But I find it interesting. Do y'all really think this damn trial is going to happen in February? Because I'm willing to bank it's going to be all the way up until June or July of next year. How the opening case is going to go. We want to do what's called a cheat code here and see if you come up with the best 4 things that the lawyer is going to do when he does his opening statement.
4 things, in my view, happen in the first 60 seconds of an opening statement. Thing number 1 is it commands attention, and that's what we've been carping about. You have to get their attention very quickly. Thing number 2 is it frames the case. It tells the jury what the trial is really all about. In other words, not what the jury charge is going to say, what the prosecution says it's about. You need to frame the story in a way that benefits you. Thing number 3, it introduces a story. Again, all great trial lawyers are storytellers, but not all trial lawyers are great storytellers. So it introduces a story, and juries just don't decide on facts. Spoiler alert, they decide on a story based on organized fact. The hook plants the story. The 4th thing that happens in an opening statement is it earns trust. A specific, honest, evidence-anchored opening statement is the key to gaining trust and keeping trust. So those 4 things, commanding attention, framing the case, introducing a story, and earning trust, all 4 of those things have to be executed and obtained. And if they are, you're on your way, Hoss.
Let's be completely clear and honest, right? When your lawyer steps away, your lawyer has to tell the judge and the whole entire judicial process why you can't go. Maybe you're indigent, meaning you can't pay, or maybe the client is a bunch of things. There's so many things you can come up with, whether they listen, whatever the hell, right? They're belligerent, or they just don't want you, flat out. It doesn't matter. There's that. But Bradford Corn was let go because 2 alphas can't exist in the same dang room. We're talking Godzilla versus King Kong. But he makes a hell of a point that I hate to say I agree with to a certain point.
All right, here we go. We're going to talk about a little Dirk a little bit. Of course, Erin Labonte is in the background talking about something on her phone, so she's going to try and ruin this video as much as she can. But we have a guest star this evening, and that's Erin Strumroll. There she is, Zoe Erin.
And we're talking about Pooh Shiesty, not Dirk, I think.
Oh shit, we are. Whatever, we'll talk about both. So let's talk about Pooh Shiesty first. So I've been reading, what's going on in the case, and my opinion is, I did the bond hearing, I looked at the evidence. My opinion on the case has not changed. I think it's a very weak case for the feds. I think it's extremely beatable. I know people are talking about, there's all this evidence, there's actually not that much evidence in terms of what went on, number 1. Number 2 is, I don't even think the feds have jurisdiction over this case. I have no idea how it's a federal case. It, A, does not meet the elements of kidnapping for a federal case. B, there's a big problem in terms of an extortion about this mysterious contract that was signed but then never used. and no one ever talked about it. It never came out in anything. So how that was used for some sort of advantage, it's a crazy case. I still honestly think it's a great case. I know everyone says, oh, he got off the case because he thinks it's a loser. That's not true. When there's cases in different jurisdictions, I always do what's best and what's right for the client, as well as what's right for me in terms of my scheduling and how much time I can dedicate to a case. And that's kind of the big thing about it, is he's got two great attorneys that I think will do a very nice job for him. I think they're going to file the appropriate motions. I think the case is going to get dismissed, or it's going to be greatly weakened to the point where it's not really a case. So now,
well, extortion could just be a threat. The extortion part was Pooh Shiesty put that goddamn Draco on Gucci Mane and said, sign this. That's the extortion part. So some of that shit that they be saying, bruh, they say that to sound fancy to those who can't fully understand. That's why the hood lawyer reigns supreme. Bradford Cohen, you know that. Don't make me expose them goddamn inbox messages, homeboy. But now, on a serious note, he would have a point, except the issue is will people show up? Meaning, will the person that they choked out and took his goddamn chain and the laptop from, will he show up? Will the goddamn security guards show up? Will Gucci Mane show up? So you're talking about 4 people. If they don't show up, then you're 100% right. Then I could agree with you. If they don't show and all they got is all this shit and all this little bit of evidence, well, it's going to be hard to tie the freaking laptop to freaking Pooh Shiesty and all of this shit, and the evidence of firearms and all this stuff that they don't have that we know of. So what evidence are we going to have? We're going to have a he say, she say. So they don't have the video that was recorded. They don't have the contract that was written on and printed. I'm just saying, bro, because once again, there are certain stupid people who believe, well, it's not stupid. Don't let me do that. That's very dismissive. We don't need to do that here. There are certain people who make a case that I just disagree with by saying, oh, bro, well, because Pooh Shiesty daddy went to Staples and he got the contract printed. And they're saying that's a part of the conspiracy. Well, how are you going to prove that the father knew that it was going to be basically a stick-up sign-em? Meaning, how can you prove that the daddy knew that Pooh Shiesty was going to forcibly make this man sign it all over? You know how you do that? You can't. Unless you got text messages. Unless you got some type of communication. If you got something that can show that, then sure. Then it's a gut punch and a gut punch and a gut punch and a gut punch until, we give it all up. But as it stands right now, bro, Bradford Cohen is correct. It is. It's a weak case. Say what you will, say what you won't. We're going to tell the truth around here. So as it stands right now, yeah, it's a weak case. Could he win? 100%. Could he lose? 100%. Just depends on who shows up, not just the evidence. But subscribe, turn that bell, stay notified, share to keep your people alert. Charlamagne, get over here. Try to trick academics. You thought academics is going to go for the, what is that, banana in the tailpipe? Click right here for that video or click right for the playlist, and I'll catch you on the next one.